when you're ready, I'll take a motion.
Was there any amendments that came in?
There was not.
Oh, okay, I'm
I
not
move
looking
on to
at something
pass.
that doesn't exist.
It does not exist.
I'll
Sarah,
second.
moved and seconded. Discussion?
Yeah, I just have one comment, which is, I know there's some concern here with sort of some of the complication in the record keeping, and I'm hopeful that we can, work with those parties concerned to address that. But, it does seem important to remove criminal penalties for mothers who want to opt out of this. And I also think, the data shows that it's a very small percentage of people that opt out when given the option. And so I think this bill does do some important things, including reminding us that data belongs to the patient. And so, I think this issue is complicated, but ultimately I'll be supporting it.
Further discussion? Seeing none, we ready for a vote? All right. All those in favor of ought to pass, say aye.
Aye.
Any opposed? Seeing none? Do you want to move consent?
Make that motion.
Second?
Moved and seconded. All in favor of consent?
Aye.
And would you like to take this one up?
Sure.
All right, Senator Perkins Coker will take it up. Next, we will do Senate Bill 106. We do have an amendment for that one.
Yes.
Wait, another one, or the original?
I think there was one that came in this
0639S.
morning, wasn't there?
639S from
Yeah.
Senator Benson.
Yes,
Yes,
there it is.
okay. 06.
I have amendments in about 4 places.
Yeah, right.
Okay.
All right. When you're ready, I'll accept the motion.
Move OTP.
Do we have a second? I will second.
Okay, thank you.
Who wants to move Senator Fenton's amendment?
So moved.
So moved. All right, we have a, Senator Altshuler's moved Senator Fenton's amendment 0639S. Do we have a second?
I'll second.
Seconded? All right. Discussion.
Well, if I may, Mr. Chair,
Yes, Senator Carson.
one of the things I had here was we needed an amendment on the placement of this, where this was going to go, who was
Right.
going to be in charge of this. And I think here it is on line 11 in the Bureau of Child Development and Head Start collaboration. So that satisfied the concern that I had.
Okay.
They just, and then the rest of it, I'm okay with. So I'll support this amendment.
I had highlighted that same line, and I believe you're correct, so I'm good with that. Any further discussion?
Yeah, so this bill actually creates a space, a really great space for people coming out of high school programs who have been working in childcare and are going on to pursue that to get into the workforce with real time, the 500 hours and 200 hours observation, with lesson planning and practice teaching. That's a very high bar, and what we heard was there are a lot of people who are pursuing the degree that gets them in the workforce while they are increasing their education. So hopefully this will let us get more childcare people into the system so that we can get more kids into the childcare.
Further discussion? Seeing none. All those in favor of the amendment? Aye.
Aye.
Any opposed? And I apologize, I don't remember who originally moved it. Did you move ought to pass?
Yes.
Okay, so Senator Altshuler has moved ought to pass as amended on 106 with amendment 639S. Do we have, and I seconded, I believe, so I think
Yes,
we're all
you did.
set there. Any further discussion? Seeing none. All in favor?
Aye.
Any opposed?
Mr. Chair, I move consent.
Second?
Moved and seconded on consent. All in favor?
Aye.
Senator Altshuler, would you like to take this one out?
It would be my honor.
Awesome. We appreciate it.
Okay.
Senate Bill 130 is next.
Okay.
She's looking at SB 74 right now.
Yes, okay.
Sorry, I forgot that. I
That's okay.
looked at my little list of homework and thought I had done it all.
All right.
We
so
all have one or
two-
two things on our calendar.
Yeah,
Mr. Chair, I move Senate Bill 130 ought to pass.
Second.
All right, moved and seconded, and Senator Carson, I believe you have an amendment, correct?
Yes, I do. It is amendment number 0474S.
Senator Carson moves the amendment. Is there a second?
Second.
Senator Carson, would you like to speak to it?
Yes, thank you, Mr. Chair. This is just language that I received from the court, just for clarification purposes. And that's it.
And I will say that I had asked last week that we hold this bill and let the Sheriff's Association meet on it, and they did and came back in support of the amendment, so we have a thumbs up from them.
all right.
Further discussion? Seeing none, all in favor of the amendment to 130, Amendment 0474S?
Aye.
Any opposed? And Senator Carson, you move out to pass as amended?
Yes.
And seconded by Senator Gendro. Any further discussion? Seeing none, all in favor, say aye.
Aye.
Any opposed?
I move consent.
Second?
Consent has been moved and seconded. All in favor?
Aye.
Senator Gendro, would you like to bring this one up?
Sure.
Um,
Senate Bill 147 will be our next one. This is relative to the Board of Dental Examiners.
I move ought to pass.
Second.
Ought to pass and seconded, and I think we have an amendment,
Yes.
right? I just have to find it. Is it in my book here?
It is amendment 0476S.
Hold on, my
Amendment.
apologies, I'm still looking for my copy. There it is. 476S?
Yes,
Okay.
476S.
I have got it.
Don't think I have that. Hang on. One. Oh, 631. Nope. You have an extra copy somewhere?
If not, we can certainly get one. Let me look and see if I have another one in my binder. 147. Let's see.
Everyone should have gotten it.
I've got doubles of, triples of one amendment, but I don't have that one.
I got one here.
Thank you.
Yeah.
You're welcome.
Mr. Chair, if I might, we have put aside a couple of bills because we're waiting to hear. Why don't we put this one aside? We'll get the amendments in that way.
I think, is
Folks
everybody
can
all
look
set?
at
I got it.
Okay.
0476?
Yes.
I think we're all
got
set.
Okay. Mr. Chair, one of the things that I looked at when we did this bill was, if you look at the bill on page 2, beginning on line 22, is what I did do was I removed on line 25, the language, the board may exempt dentists who are board eligible or board certified in either dental anesthesiology or oral and maxillofacial surgery from this requirement. I strongly believe that if someone is going to, if an anesthesiologist is going to put someone into a deep sleep, that there should be more than just one person in the room. You never know if there's some sort of problem, and the anesthesiologist who's actually performing the procedure is going to be focused on that. And so I just feel as a best practice for medicine that you just have more than one person in the room. So I
Further
just removed
discussion?
that section.
Well, I appreciate the work that you did in putting this in, but I still have,
Excuse me.
I still think that this adversely affects smaller practices where they have, where the the dentists who are board certified in dental anesthesiology and have, nurses on staff who are also certified but are not general anesthesiologists. I think it's a knock on them. Yeah, I can't get behind this one, but that's, I don't think that's gonna change the outcome here. Yeah, just-
Senator, if I may,
Yeah.
Mr. Chair, I'm more concerned about patient safety, and making sure that a procedure is performed in a safe environment. If you go to just about any physician, there's always a physician and someone else in the room, whether it's an LNA or it is a medical assistant or a nurse. There's always someone else in the room. And I think that is a best practice. I was contacted by some constituents who were aware of this bill that were very much in support of this bill because of issues that they had either with themselves or with their children. So I feel very comfortable with removal. I understand your point, and we can discuss it on the floor.
Yeah, and I'll just add to that, Senator. I see Senator Altshuler's point. I see your point for sure, and I agree that there should be a second person in the room. I think respectfully, we're just saying that both of the people in the room do not need to be certified as anesthesia providers. If one is, then that should be sufficient to make sure the anesthesia procedures are followed. But then obviously having the second person in the room provides other safety that, as a woman, I very much agree with, and certainly for children. So I think that's just the concern we're raising, but I also appreciate your work on this bill.
Yeah.
I think it's important.
I have no, just to be clear, I don't have the objection to there not being someone else in the room or to create a space where that is not necessary. That is not what I'm saying at all. What I'm saying is your reference to, say, an LNA. There are also dental assistants who have the same level of training.
Correct.
So if an LNA would be okay to be in a room, then our dental assistant would be okay. But it's my experience and what I have heard from, my district, a couple of people in my district, is that it's for very, very small practices, it's a huge, it'll be a big lift. And it favors larger practices who are able to really, really staff up. It's a lot to get to be board certified in dental anesthesiology or maxillofacial surgery. It's a big deal. To have 2 people on staff is really expensive. So do not disagree that there should be 2 people in the room. Do not disagree that more eyes on patients is better for patient safety. Just don't think that that level of education and is necessary at all of these procedures. So
I guess I'm struggling to read it the way you're reading it, and I'm trying to. Maybe I'm not understanding what it's saying.
So in the amendment, in addition to the dentist performing the procedure, there shall be a dedicated anesthesia provider. And then at the bottom, the part that's struck, the board may exempt dentists who are board eligible or board certified in either dental anesthesiology or oral and maxillofacial surgery from this requirement. So if the dentist is the certified provider of anesthesia, this bill would require there be yet another one. So the dentist would not be able to be the one. So
But he
the
could
other
be-
person in the room has to be yet another board certified doctor
Right.
or anesthesiologist. It says physician anesthesiologist, that's a doctor, or registered nurse anesthetist. CRNA, those are high levels of certifications.
Mr. Chair.
Certainly,
what am
please
I
do,
missing?
so I'm trying to
I
understand.
agree with it to a small degree to what you're saying, but in addition to the dentist performing the procedure, okay, there has to be a dedicated anesthesia provider present to monitor the procedure, and that dedicated person can be the dentist, qualified to administer general anesthesia, deep sedation, a physician anesthesiologist, or certified registered nurse. We're talking here about one person, the dentist who is performing the procedure, okay? And there has to be another one present. But what I took out is the exemption, okay? So there has to be two people. There has to be the person who's actually performing the procedure and someone who is the anesthesiologist.
I heard-
who's
yes.
monitoring. And so what do you do if you're going to accept the dentist who's doing the procedure but who's also board eligible or board certified? So now you only end up with one person in the room, and that is the person who is performing the procedure and who is an anesthesiologist.
That
And
doesn't,
what I'm
yeah,
saying is that from the feedback that I've gotten, that's not really a good thing to do. Because if you're the surgeon who's performing the procedure, you're concentrating on doing the procedure. The anesthesiologist, the second person in the room, is focused on the anesthesia, whether or not you're getting the proper amount, if you are having any kind of adverse effect. You are going to depend on one person who's concentrating on doing this procedure to also monitor the anesthesia. And I don't think that's a good practice.
Okay.
That's my concern. I understand what you're saying about for a small practice, but I'm looking at patient safety. I know that if I was to take myself or my child and I had to have dental work done where I had to be put into deep sedation, I would want the dentist who's doing that procedure to concentrate on that procedure. And I would want an anesthesiologist or one of these other folks, a physician, anesthesiologist, or certified registered nurse anesthetist, to be concentrating on the anesthesia. Because I got a phone call from a lady, her son went in to have his wisdom teeth done, and usually what happens is they put you to sleep. There was only one person in the room who was the dentist, and in the middle of the procedure, her son woke up and was in a tremendous amount of pain. They had to re-administer the anesthesia. So he had to stop the procedure, what he was doing, and re-administer. And I'm not a doctor. I don't pretend to be a doctor. I just don't think that's a best practice. And that's why I took that exemption away. That's all. So have I confused everybody?
Nope.
no, no,
think-
I
That was
understand what
actually
you're
really
saying
helpful.
completely.
Yeah.
And while I have no knowledge of your patient, it does, from that example, it sounds like that doctor did not administer the anesthesia in the first place appropriately, and you've got somebody who woke up. Whether the patient wakes up and the doctor's going to have to stop anything to re-administer anesthesia, whether the doctor is administering it or a second doctor is administering it. Somebody messed up in that situation. Having two people in the room doesn't stop that first person from messing up in the first place necessarily. It's not uncommon. It's really not uncommon to have your dentist administer your anesthesia for a root canal or for wisdom teeth. And if the goal is to just get a second person in the room, I would be interested to hear if there are practices where there isn't a dental assistant in the room or another person helping in the room. I think it's a really high bar to ask physicians who have small practices, who have done the work in getting certified to be able to do the anesthesia for root canals and for wisdom teeth and for putting in crowns, that they now have to hire another person into the practice with that level of education when they may already have a staff available who is trained to do the work with this dentist. I just think it's an exceptionally high bar. I also do not want to put patients in danger. I don't think it endangers them by having two people in the room and one of them is somebody who works in the practice as a dental assistant or another nurse, but having to require 2 people to be certified anesthesiologists is just a high bar. So if the goal is, if patient safety is achieved by having 2 people in the room who have training in the field of dentistry and one of them is the anesthesiologist, awesome. Let's do that. But if the goal is, I don't know that there are practices who don't have 2 people in the room. I just think taking away the exception for that, solo practitioner dentist who has a staff to have to bring on another dentist or anesthesiologist is a really big lift.
Senator Carson, yeah.
Thank you for your comments, and I can understand that, but it's in addition to the dentist performing the procedure. So that dentist does not have to be board certified or eligible in dental anesthesiology. That you can just have a general surgeon, a dentist who's a general surgeon who's just going to be removing teeth or whatever the procedure is. And if the other person in the room is the anesthesiologist, their job is to monitor the anesthesia. So if they see that a patient is starting to wake up because they monitor everything, they're going to be able to resedate them right then and there. Whereas if you've got the doctor who's doing the surgery, oh, they woke up, I got to stop doing this, and now I have to re-administer anesthesia to put them back to sleep so I can finish the surgery. I just think it's a safer practice to have 2 people in the room, one being the surgeon who's actually performing the procedure, and if you are doing a deep sedation where you are putting the person asleep, to have that person be an anesthesiologist. And you've got, you can have a dentist who is qualified to administer general anesthesia. You've got a physician anesthesiologist or a certified registered nurse anesthetist. You have a choice about the other person. But the way that I see this is about patient safety more than anything else. You want to make sure that when the patient goes in, that they're going to be treated appropriately. There have been issues over and over and over dealing with the misadministration of anesthesia. So I want the confidence of knowing when I go to my dentist and I need to be put to sleep, that there's an anesthetist there. Because what happens if I have a reaction? Some people do have reactions to anesthesia. So the dentist here is working on the actual procedure. The anesthesiologist is monitoring the anesthesia. That's what I feel comfortable with, and I hope all of you can support that.
Well, if I may, I will admit, when we originally were looking at this amendment, I thought we were more talking about having a second person in the room along. So the problem comes, I guess, with the dentist who is qualified to be the anesthesiologist as well.
That's
Or
an
anesthetist, I'll get the
Right.
word. I thought what we were really looking for when we were changing this, my original thought was that we made sure we had someone else in the room to monitor that there was, things were done properly. I didn't realize we were looking to have a separate anesthetist from the dentist to monitor the 2. My thought was we were just having someone there to monitor the patient and make sure that there was no foul play or anything, call it whatever you want, make sure that things procedurally went well. So I now understand why you're seeing this as a higher bar. I didn't understand it in the beginning. So thank you both for that, because I've learned something.
Well, good.
And I appreciate that.
And in addition, I just wanted to bring to the committee's attention, if we go back to the original bill, this is a rule specific to deep sedation to patients under the age of 13.
Yep.
So I just want to point that out to Senator Altschuler, if that's helpful at all. I'm not implying it would change your opinion, but I just want to make sure you knew that. I think ultimately, I very much agree with your workforce points. I think where it's restricted to children, ultimately, I find Senator Carson's arguments convincing in terms of like having someone else there to monitor, just because kids are so delicate. But I think you make a lot of really good points on this.
I think you both have, quite honestly.
Yeah,
And it's been a great discussion.
it has. I agree.
Yeah, check your dentist.
Yeah. Well, I'm not under
Each make it-
13, so it won't
Right,
matter.
right. Okay.
Well, your children.
Further discussion? All right, so we'll be voting on the amendment.
Okay.
All those in favor of the amendment, say aye.
Aye.
All opposed?
Nay.
So we have 4 ayes and 1 nay. The amendment passes. Senator Carson,
I'll make a motion to pass as amended.
and
Second?
seconded by Senator Gendro. Further discussion? So we'll be voting on 147 ought to pass with the amendment. All in favor, say aye.
Aye.
Opposed?
Nay.
Nay? So we have 4 to 1.
And
So
I'll take it out.
you'll take it out?
Yeah.
All right. Great discussion, thank you.
You're welcome.
I appreciate that. I see that Senator Prentice is here, and so we will do Senate Bill 204 next. She had called and asked if she could come in and talk about an amendment she wants to bring. So Senator Prentice, I would recognize you to come up and talk to us about an amendment you want to bring.
I'm sorry, which bill, Chair?
204.
Good morning.
2-0.
So good morning, Chair Pearl, my friends in eDNA, it's good to be back in the room. So you are receiving an unapproved version. I've been back and forth with OLS. This is actually from my hot printer, and I'm waiting for their final version. So this could be a committee amendment, or you could wait till the OLS draft comes in. But so what I did is I took Senate Bill 204, which is putting the trauma kits in state-owned buildings, owned and operated buildings, and I made a few changes. First, I want to draw your attention to under Roman numeral 1, the trauma kits themselves. Instead of just saying all state buildings, because when we talk about all state buildings, that could include buildings, space that is leased. And in talking with Commissioner Arlinghouse, what we originally planned on was 221 buildings that were throughout the state that had the most public, or like the most high traffic, where we could provide maximum protection, and then hoping towards the future, and that's why there's a fund established. If we can bring more funds into this, we can actually continue to build out and put these in other buildings. So I struck all state buildings and put state-owned buildings, and order of installation will be identified by a committee that I created under a new section. So first is, it's not all state buildings, we're just saying state-owned buildings, and the order of installation will be determined by a committee, and I'll get to that in just a second. In section 2, the trauma kit itself, Senator Gendro brought up an excellent point when talking about scissors. You know, in the profession of emergency medical services, we think of our scissors as being something we call trauma shears, and they're blunt-ended, and so they can't hurt a patient when, say, you're cutting off their clothes. But the concern here was that someone could grab those scissors and actually potentially be harmful versus helpful. So I didn't want to be proprietary, so I just changed it to being, so it's item D under 2, blunt-ended scissor. So that would cover the trauma shears or other types of medical scissors that are blunt-ended and used to either cut off a patient's clothes or do any work close to somebody's skin. And last but not least, this is on page 2. It's going to be 153A, 33D. What I did is I created a trauma placement kit committee. So they would decide, this would be housed at the Department of Safety, Bureau of Emergency Medical Services, and they would decide what state-owned buildings to place the kits within, the criteria for placement, and identify future placements. And that the Commissioner of Safety would appoint a representative from the physicians group, like one of the physicians that came in here to talk from the Medical Control Board, which is cited in statute. They would appoint somebody from the Bureau of Emergency Medical Services, because they'll ultimately be responsible for this in their statute. And lastly, somebody from Administrative Services, leaving that up to their commissioner on who would be the appropriate person. So the idea here is to, again, focus just on state-owned and operated, give it to a committee to decide that first 221 based on what Commissioner Arlinghouse and I had talked about, the most high traffic, like courthouses, okay, DMVs, and thinking that we have a future to potentially build this out, it gives that room. So these are, again, my unofficial amendments. I had a back and forth with OLS about administrative services, so they're creating the unapproved official version now, but this is what they will be working with. This is what they have.
Thank you, Senator.
Questions?
Thank
Do you feel that creating this commission will impact the fiscal note in an appreciable manner?
I don't. I mean, it's been my experience that these small groups, they meet infrequently. We did this, we had an AED, even though this isn't a commission, there was money given to the state. A commission was set up for the placement of automatic external defibrillators in public schools using private gifts that came in. And it was, it was actually a larger group. It met infrequently. It had a very strict charge, and they did their business. And I actually sat on it, and it was not a lot of time, but it was very important to have that group of experts know exactly where these should go, and what the higher priorities are. So the long and short, no.
My second
That
question.
fiscal note's really just about the cost of the kits.
Yeah, that's what I thought. I didn't think so either, but I wanted your opinion.
It's great, thank you.
The second question that I have is this, just for clarification, this only applies to state-owned buildings. We're not doing any municipal buildings, so we wouldn't be impacting schools or
No.
anything like that. Okay, that's what I thought. Thank you. Further questions from the committee?
Nope.
Seeing none, thank you very much.
Thank you
Thank
very
you,
much.
thank you for the opportunity, and always good to see you.
All right.
Okay,
is this coming today? Like, before we're done, we can,
do you know if they're currently drafting this? I mean, we can do this as a committee amendment. We can
Oh, we
use this
can. Oh,
language,
okay.
absolutely.
oh, I didn't know if we had to wait for the,
Hopefully they are, but I also am giving deference to them because they have so much on their plate this morning,
Understood.
especially this afternoon. Oh, yeah, this one.
Yeah,
So-
because we can just
We,
use.
we can just use this and do it as a committee
oh, all
amendment.
right.
Yep,
we can.
sounds good.
Things you can do in the Senate.
Thank you.
Thank you, appreciate
Yes.
it.
Yeah,
A little more.
yeah, a little more forgiving.
Yeah, absolutely.
So, Mr. Chair, I
Yes.
move that we create a committee amendment with the changes that we've received.
Moved and seconded. So remind me again, doing a committee amendment,
Yeah.
we treat the amendment as an amendment, and then we do it as an OTPA after that, correct?
Yes, we
Okay,
have
thank
to,
you.
we have to create the amendment.
Got it.
And the amendment would be, and I'm looking at the copy that we've received from Senator Prentice. On page 1, beginning on line 5, we're gonna cross out all state-owned buildings, and what we're going to do then is a trauma kit shall be installed and readily available, period. We're gonna cross out in, and then it's gonna continue, the state-owned buildings in order of installation shall be identified by a committee established in section 5, and then it gives the reference. That's the first change. The second change is on line 13, and we're going to cross out,
Well, it's line 11 of the original bill.
oh, okay, because
Yep.
I'm looking here because I have line 13.
Yeah, it is on her section, but it's line 11 of the original.
You have a
bill.
copy of this, right? Yeah.
Yeah.
Okay, so, we cross out scissors, blunt-ended, specifically used for patient care, and replace that with, blunt-ended scissors.
Well, the original bill just said one pair of scissors, so we'd be adding the word blunt-ended.
Right, but crossing out,
Well, I think that's probably a draft that she's
That
been
was a
working on
draft.
with
Agreed.
OLS.
In the original, it just says one pair of
Yes.
scissors.
okay, all right,
One pair of blunt
So we
ended
just
scissors.
are inserting the words blunt-ended.
okay. Again, I'm going off
That's
of
okay.
what she has.
I have the advantage of having both here right in front of me, so
Ah.
I'll compare as we go.
And then there's that whole new section, on page 2, 153A:33D, Trauma Kit Placement Committee. And you have that language.
Yes.
So
Which-
that would be the amendment.
Which would be added in on page 2 of the original bill under line 3.
Correct.
So just one minor niche, Senator Carson, I think on the first edition, we may want it to read, a trauma kit shall be installed and readily available in state-owned buildings, period.
She
The,
had that
Yeah, she's
stricken
got a
out.
period in there.
the state-owned buildings and order of installation will be identified. So a trauma kit shall be installed and readily available
I think
in-
she wants to cross out the word all,
I think just all, right?
So that it
exactly.
Oh, yeah,
says
that's a
in
little,
state-owned
that's just a
buildings.
little arrow
Okay.
to point to
All
the
right,
beginning
okay,
of the
I see.
strikeout.
Yep.
Yeah.
Yep, nope, that's okay. So-
Okay.
You got that,
Great.
Phil? Okay,
okay.
all right, so we have a
Okay.
potential committee amendment.
All right, any discussion on the amendment?
No.
Seeing none, all those in favor?
Aye.
Any opposed? And then Senator, I don't remember who moved this, Senator Carson, did you want
Yep.
to move out to pass this
Yes, I
amendment?
do.
Do we have a second?
Second?
Seconded by Senator Perkins Spolka. Any further discussion? And this will be 204 with the committee amendment, is what we're voting on.
Yes.
All in favor, say aye.
Aye.
Any opposed?
Move consent?
Second?
Moved and seconded, all in favor?
Aye. And I can take this out. if
Senator
you want.
Perkins Spolka will take it out. All right,
Okay.
nicely done. We have not heard back from Commissioner Arlinghouse, have we?
We have,
Okay, we would like to do 74 next one?
sure.
All right, Senate Bill 74.
Back
Okay.
to 74.
Senator
So,
Perkins Spolka, did you want to make a motion?
I move SB 74 ought to pass.
Do we have a second?
Second?
And you
And
have an amendment.
I'd like to introduce amendment 2023-0606S.
Oops, I'm on the wrong one. Hold on a minute. 74.
And, sorry, committee, for not having this when we started, but
Okay.
I did run this by Commissioner Arlinghouse. He looked at it personally himself this morning, and he said he has no issue with this addition.
Okay. Did we get a second on the amendment?
Yes, I
We
did.
We did, okay. Thank you. Okay, further discussion? Seeing none, all those in favor of the amendment? Aye.
Aye.
Any opposed? Senator Perkins Spolka moves ought to pass as amended.
I'll second.
And we have a second from Senator Carson. Any further discussion? Seeing none, all in favor?
Aye.
Any opposed? Anybody want to move
Move consent?
move consent?
Second,
Seconded, all in favor?
Aye. I will take it out.
Senator Perkins Spolka will take it up. We have not heard
I
back from
guess.
Senator Susie, correct? She was, 10:15, I'm sorry, we aren't there yet. Okay, then we'll continue on till Senate Bill 149.
40. Did we just,
So there were,
130? Did we do, did I
We
miss
did do
writing
We did
that down?
130,
Oh, I didn't
yeah.
put it on my sheet, okay.
we did 130
Yeah,
and
we did
147, and we're on to 149. We're making good progress.
We
OTPA.
are.
So, you'll have to bear with me a second, because I
Did we
have,
put 130 on consent?
did.
yes.
We did, all right. Who's better than us? All right, where are we now?
Who's bringing out 130? Was that Senator Carson?
Oh, no,
Oh,
just,
Senator
no.
Gendron. Yep.
Yeah.
I apologize. I have amendment language here that was proposed amendment language. I'm just trying to get my eyes on it. I know it's in, there we are, right
All
there.
right, 149.
So did we act on 49?
Yeah.
49.
Yes, we did that last week. I believe we did it last week.
Okay. Non-lapsing fund, 5-0 consent. Yep, okay. I just didn't do my folders the right way.
All right, Senate Bill 149 was the nurse agency one where we had concerns raised about making all that information available. And we have a proposed amendment. I don't know, I think I gave you all a copy of it. It should look like this right here.
Yeah.
Yes.
Okay. So that is language that is a proposed amendment that was brought in by the nurse staffing agencies.
Okay.
Okay.
Mr. Berkey gave it to me and has spoken with them, and
Okay.
they are okay with this language, so he's asked me to present it to you guys to look at. I haven't had an official amendment drafted up because we just got it last night, but again, we could do this as a committee amendment if we
Okay.
choose we want to.
Okay, so nurse agency registration.
So I'll give you all a minute to kind of look at this. Would you like to hear from Mr. Berkey? Would that be the
Could be
the will of
helpful.
the committee? Mr. Berkey, would you like to come up and address the committee? You can probably explain the amendment quicker than we can try and figure it out. Thank you. Turn your mic on.
Thank you, Mr. Chairman and members of the committee. I was a little inartful in how I drafted it, tried to have all the numbers on the sides and so forth. And what it did was, it preserved the first 21 lines of the original bill, which talked about the licensing process for a nurse agency. And I changed that to a registration process, and that it should be done within the Department of Labor. The statute numbers that I have there are just referenced from the original bill. They wouldn't be for the Department of Labor's statutes. But that similarly, there's a statute within the Labor Department's structure for leasing companies. And leasing companies have some similarities with temporary help companies and staffing companies. And so in this instance, we changed it to a registration because there really isn't anything to license. There isn't any skill like an engineering skill or a nursing skill. Those people are licensed. This business would not be licensed. It would be registered, create some transparency, and allow for the state to know who is operating in the state and where. And that's what we do in the last section, or the second to last section on page 2, beginning on line 22. I drafted language that would have the nurse staffing agencies required to submit their client lists and where their nurses are working. So if they were working at nursing home A, that nursing home A would be on the client list for the nurse staffing agency. And this would be confidential and proprietary information that the Department of Labor would have, but it would allow for the state to have that transparency of where these staffing agencies are operating and what services they're providing. And finally, as I think I shared at the public hearing, there is a remedy already in place that hasn't been used by these facilities, healthcare facilities that I'm aware of. I spoke with the Attorney General's office and their Consumer Protection Division, and they have had no complaints from healthcare facilities about these staffing agencies. But RSA 358A is the Unfair and Deceptive Trade Practices Law, and that is a remedy waiting for anyone who is concerned about the practices of nurse staffing agencies. So in a nutshell, that, this amendment has them registering, has the transparency in place, and does not invade the business operations by requiring information about wage rates and everything else. So thank you for this opportunity to explain the language.
All right, so for my own clarification, so the first section, 150, 154, the definition, that part's okay.
Yes.
But the 150, 155 nurse agency registration, we'd need to change that reference?
Well, I think perhaps all of these statutes would have to, the statute numbers would have to change, Mr. Chairman.
Oh, okay.
And
To
they
get
would-
it into the labor.
to put it into the labor statutes, yes.
Further questions from the committee?
I'm looking for the bill. So, Mr. Chair.
Sorry, Carson, go ahead.
Yeah, we received, I know I received an email, and I know it's here, concerning a compromise. There's been suggested that the state agency in charge is OPLC, not DHHS. And now we're looking at the Department of Labor being in charge, not OPLC.
And if I may.
Yeah.
I would not recommend OPLC, only because that is a licensing division. And here, there isn't anything to license. It's a business. It's a business that's operating in the state. They have licensed individuals working for them, nurses. But in this instance, the actual business would not be licensed, and there wouldn't be anything to license. They would be registered in the state, registered to do business in the state, and in this case, there'd be like a dual registration, because they would have to register with the Department of Labor.
Mr. Berkey, I'm not too sure about that, because we're talking about people that are providing medical care. and the individuals are licensed
Correct.
for these companies. I'm not sure I agree with you. I'd have to really think about that. I understand why you want to put it in the Department of Labor, but this really is about healthcare and the delivery of healthcare. And I can understand why you wouldn't want it to be in DHHS, but there has to be some oversight of these businesses, because I think that was really what the crux of the bill was. It's the fact that these businesses are coming here, they're providing essential medical services, and at an exorbitant cost that our county nursing homes can't absorb anymore. And they don't have a choice. They have to provide this service unless we start shutting them down. We had testimony about smaller nursing homes that have had to close wings because they don't have the personnel. So I just don't think that this is just something that would apply to the Department of Labor. I'm not sure. I have to think about this.
So do we know anyone else who's providing a service into the medical field? Do they, the business itself, are they registered under OPLC or are they registered under the Department of Labor? And I don't know the answer. Do you know the answer?
Well, I think that particular disciplines, particular professions, doctors, nurses, a myriad of different types of providers, they are all licensed within the state of New Hampshire. Or they have a certification process or whatever level of oversight that they are subjected to. But I would suggest that, I sometimes have to go to Concord Orthopedics. Those doctors are licensed, those nurses are licensed, but I don't think Concord Orthopedics is licensed. They're registered to do business in the state, and we would suggest that, certainly Interim Healthcare, Mr. Peterson's company, they are registered with the Secretary of State's office, and, under the guidelines that I'm suggesting here this morning, they would have to also register with the Department of Labor so that the state of New Hampshire knows which healthcare facilities that they are contracting with and where they are placing staffing help.
Okay. Any further questions for Mr. Berkey? Senator Altshuler, did you have one?
Yeah, I appreciate thank you for putting this together. I am as flummoxed as Senator Carson right now in trying to figure out the licensure of the practice versus the practitioners. I don't, because I have quite a few notes about this being an OPLC. So, but what I'm mindful that you've taken out all of the reporting for average amounts charged.
That's correct.
Right. And an average amount, after our testimony and subsequent conversations, it occurred to me that this language in the original bill doesn't ask for specific pay rates. It asks for an average amount charged. So it's, in a subsequent conversation from the hearing, I had used the analogy of a rate card. So they've got to have a rate card, to operate the business. That, perhaps people coming in new have a different rate. There might be steps, there might be levels, depending on different certifications. But, an LPN with 15 years experience might make more than one with 10, who makes less than one, an RN. And this bill doesn't ask for all of those specific salaries. It's just asking for an average, which seems to be able to like thread the needle between getting that specific rate card that I believe you had said was proprietary information and a little more transparency as to how much is being spent. Is that still an uncomfortable place?
That still is an uncomfortable
Okay,
place.
I hear you.
You know, it's a private business, and they are able to negotiate with their prospective clients. And those prospective clients in healthcare facilities can say yes, or they can say no to contracting with a particular staffing agency. And I recognize that, you know, we just came through a pandemic, and that was a very unique circumstance. It's my understanding from talking with Mr. Peterson that the impacts of the pandemic are definitely receding right now within the business, and that rates are coming down because there's still burnout out there. I don't want to suggest that there isn't, but in terms of the relationships and the contracts that he is involved with, both in the state of New Hampshire and the state of Maine where he operates, he is seeing those rates come down as a result of the easing of the impacts from the pandemic.
Okay,
Senator
please.
Jenner.
Just trying to think this through too. Here it is a private enterprise. So that is the business, the private enterprise, which would go under the business aspect of it. And I'm thinking about there's an employment agency in Littleton. It's a private practice, private industry. Under that, though, she has people that are certified in different areas. Right. So her business is not necessarily certified. It wouldn't go in OLC, or what is the
OPLC.
OPLC. It wouldn't be in that. Her business wouldn't, but she has people that would probably fall under the category in OPLC. So I think we've got two separate things here, the business itself and then those that are certified.
That's correct.
Okay. All right.
Further questions?
Not for Bruce.
Thank you.
Thank you. Appreciate it.
Kate, did you have some comments you wanted to make?
Thank you, Mr. Chair and members of the committee. I will point out, nursing.
Give your full name so the record.
Oh, sorry. Kate Horgan, New Hampshire Association of Counties. I will point out county nursing homes and private nursing homes are all certified and licensed at OPLC already. So we don't see a difference. Their business is licensed separately from their nurses who are licensed. We don't see a difference. We did propose an amendment to Senator Carson, and I believe Senator Gendro got a copy as well.
This is the one from Alex?
From Alex,
Yeah,
yes.
okay. I hadn't gotten to that one.
Okay, perfect. So that is the one that we felt we had given some things on and would work for us. I just saw Mr. Berkey's amendment this morning. I sent it off. I haven't gotten feedback yet from my people, but I have a feeling they will not be happy with that amendment.
So for the committee, you should have received a second amendment by email.
I did not.
Okay.
So
And
I've not
I
seen that.
apologize. I only printed one for myself. Do you have copies you could provide for the others? If not, we can
I
get some.
do not have
Okay.
copies with me. I just got it myself this morning from Alex.
All right.
Mr. Chairman,
Yes.
if I might suggest, it seems like there's a lot of things moving around
Yes.
here. I don't feel comfortable voting on this.
Yeah.
I know it is a fiscal note bill, but we can put it off until we come back, I think it's March 8th.
Yes.
Because we have to have fiscal notes out by the 9th. So I would feel more comfortable seeing all these papers in front of us. And I'd like to hear back from Ms. Horgan about the counties because they're the ones that really talked about this, and have them respond to us and let us know what they think. And then at that point, hopefully, the parties can get together and resolve this and come up with something for us.
No, I think that's fair and reasonable. I wanted to bring it out today so we could sort of just start having this conversation. And,
Yep, and I'm happy to get feedback for the committee on Mr. Berkey's
I
amendment.
do have
Thank
one
you.
question actually for you.
Yes.
So the counties you said the county facilities are licensed,
Yes.
but are the nurse, so the contracting, I'm sorry, my head just went blank here, the providers of the traveling nurses and whatnot, they're not actually providing, they're not a facility, they're providing labor, almost like a temp labor agency is. And so that's why I'm trying to get my head around it too, and I think Mr. Berkey presents an interesting point about it being a contract agency and not an actual provider, because they're not providing the care, they're providing the employees to provide the care. I know it's almost, I'm tripping over my own tongue here.
I would argue that they are performing the same administrative services that the administration for a county nursing home is providing. So the people who are running payroll and things like that, they're licensed under the facility license.
So
They're doing business things.
So our current providers of temporary staff, are they licensed under OPLC now?
Not the staffing agency, but the individual employees have to be licensed.
Correct, and I think that's
The
Mr.
same
Berkey's
as ours. So like we have a overarching facility license and
Yep.
then our individual nurses are licensed. In Mr. Berkey's case, his overall staffing agency is not licensed, but his individual nurses are. And those overarching staffing duties, we also perform at the county and private nursing homes
Sure.
as well. They aren't here today, but they're across the hall. They're performing those same functions that are happening at the staffing agency level.
So a staffing agency from another state, we should require a different license than we would a staffing agency within the state?
Yes. Well, it should be the same for a staffing agency. It should all be the same. But my point is a nursing home has a facility license.
Yes.
They are doing the same payroll, HR,
Got it.
intake, all that a nursing home, or that a staffing agency would do. They're doing HR, they're doing payroll, they're doing scheduling, all that stuff.
Okay, thank you. Any further questions from the committee? Well, thank you, I appreciate the
Thank you.
input. The committee comfortable with pushing this off? I mean,
Yes.
it's gonna
Yeah.
require us to meet on March 8th, but we're all good with that?
I think it needs it.
Okay, I agree. I
Yeah.
think there's a little bit more to digest than what we're ready for today, so.
Back on
All right,
March
Yes.
8th. Oh, is she here? Okay.
would we like her to come speak to her
Yeah.
amendment?
I think that would be
Yeah.
helpful.
If she'd like to, sure.
Yeah.
We'll give her that opportunity. Oh. While we're waiting.
10:15 on the dot.
Right? Well, I won't go into 205 because that will be a long discussion. I think while we're waiting for Senator Susie to come over, we could probably do 209. We have an amendment for that, correct?
Yes.
All right, so let's do 209.
Okay, let's see.
I know I'm skipping around a little bit, but I was trying to find something quick.
Yeah, this one hopefully will be relatively quick. Mr. Chair, I'll move on to pass on Senate Bill 209.
Do we have a second? Second. And do you have an amendment you'd like to offer?
Yes, Mr. Chair, I have amendment number 0631S.
Do we have a second?
Second.
All right,
Okay,
Senator Carson?
Yes, Mr. Chair, on the amendment, the only change is a reference beginning on line 6, and any facility listed in RSA 169B14. This is language from the department that covers juvenile correction facilities.
Great.
We had discussed that, and so we wanted to catch everyone that it's our responsibility because these folks are in our care and that we provide them with the things that they need.
Any further discussion? Seeing none, all in favor of the amendment?
Aye.
Any opposed? Senator Carson moves,
Ought to pass as amended?
do we have a second?
Second.
Moved and seconded, any further discussion? Seeing none, all in favor?
Aye.
Any opposed?
Consent?
Second?
And seconded, all in favor of consent?
Aye.
Senator Carson, do you want to take this
Yeah,
out?
I will
All
take
right.
this one out.
See, that was really quick.
He's not even here yet.
Is 208 a quick one, do you think?
B.
It's 209.
What is 208?
That's- Yeah, I think that's a good one too. All right, we'll do 208.
Since 208.
Do we have a motion?
Second?
Moved and seconded? Any discussion?
We had a good discussion.
I'm sorry?
I think we had a good discussion the day of.
That-
I have like all of the notes that, you know, it was, everybody was pretty much in agreement.
No discussion? All right.
Let's do it.
All in favor of ought to pass on Senate Bill 208?
Aye.
Any opposed? We have a consent motion
Consent?
So moved.
and seconded by Senator Altshuler. All in favor?
Aye.
And I can
I'll take it.
this.
Oh.
Go ahead.
Senator
I'll take
Altshuler
it.
will take
Yep.
this one up.
I'm on that one.
Were you able to reach Senator
208.
Susie Philip?
Yep,
And there she is. Look at that, right on time. Perfect cue.
OTP.
All right, next we will do
Consent.
Senate Bill 72. And Senator Susie has
72.
an amendment that she has drafted. And Senator Susie, would you like to speak to the amendment that you have presented us?
Sure, so the amendment, just to make sure you're looking at, is 0613? Yes.
All right. Floor is yours.
Okay, so the amendment has two parts. The second part was language that you were presented with at the time of the hearing from the department, which is fine. The issue that I had been working on and that I had consulted the department on was trying to find a mechanism to get these changes in status applied more expeditiously. So the language says that the carrier shall act upon the change in status request within 30 days of the receipt of the request or notify the provider if there's an issue. This issue is not new applications. New applications, I don't know how long they take. It probably varies by carrier. New applications, not the issue. The issue here is when there is simply a change in the status of the provider. So let me just give you an example to illustrate it, because I don't know if we did that well enough at the hearing. There was an issue when Portsmouth Hospital acquired Frisbee Hospital in Rochester. It not only acquired the hospital, but the entity is owned by the hospital. So that included a doctor's practice. There was an individual who was on medication for arthritis. She needed to go back to her physician for blood work, because it's required as part of this medication. I don't know exactly what the medication was, but something pretty heavy that requires this periodic testing. In that transition, this provider did not have their status. They had a window of time. So what that meant is that the individual could not be certain of the continuation of their coverage, yet needed to obtain this health care to get these tests in order to get the medication. That's all we're trying to fix, is that when notified, and many of them are simple things. I certainly understand, and that's why the language says notify if it's going to take longer. If there's an issue with a provider, an individual doctor, if there's, they've changed multiple address, the carrier has to take as long as they have to take to certify that this is a needed change. All we're saying is that when there are things like a change of address, a relocation, or a name change, somebody gets married, somebody gets divorced, that those process within 30 days, absent some additional information that would require further investigation, that we do them. That's all. We're just trying to speed up the process a little bit. I mean, I think all of us, if you read a newspaper, you knew that Portsmouth Hospital was acquiring Frisbee Hospital. But what we want to try to avoid where possible are these interruptions where it takes so long to process all of them
Thank you, Senator.
for the care. So that's essentially what the language is here.
So we had, and I have to find the right sheet here, we had a request to add a slight change in language, and I apologize.
Mm-hmm.
I have,
And I
there it
just
is.
saw it when I got here, so I
Yes.
have not talked to Heidi about it. The only concern I have with the language is it's not really an application. An application to me is a new application. This is a change in status, which is what the line 5 of the amendment, which is current law, says. It's a change in status for the health provider. I'm just concerned if we use the word application, it sounds like we're starting the process over again. And I know that there is such a thing as a clean claim, meaning a claim for the carrier to pay the provider. And I understand that terminology because I actually have another bill dealing with that issue. I don't know what a clean request is. Complete request, that certainly would make sense, but I'm just not sure what a clean request would be. And that's
Okay.
my only concern with adding that phrase. And as I said, I did not get a chance to speak with her. I just saw it this morning. I had a couple things lined up before coming here.
Understood. We appreciate you coming in on very short notice. Any
Not a
questions
problem.
for Senator Susie?
Just,
before we-
just one more. It seems that your section 2 of your amendment, Senator Susie, incorporates the amendment we previously received from Senator Carson.
That's correct. It should be the
Replacing
same language.
Okay.
Yes. Yeah, and that was presented to you, as I said, from the department at the time of the hearing.
Yep.
We agree to that. It was, the additional portion is the first portion. That's why
Got
I had to address that.
Okay.
Further questions?
No, ma'am.
Seeing none, thank you.
Thank you. Thank you.
Heidi, do you want to come up and just
Yeah.
talk with us for just a second? I'm thinking that would probably be beneficial to the committee.
Good morning, Mr. Chairman and members of the committee. For the record, my name is Heidi Kroll. I work at Gallagher, Callahan, and Gartrell, and I represent AHIP, which is America's Health Insurance Plans. We're the trade association for the health insurance carriers. So we received Senator Susie's proposed amendment last night, just a little bit before 4 o'clock. So I've been kind of scrambling around late yesterday and this morning getting feedback. And I think the carriers are fine with her proposal. With the one piece of feedback that I did receive was to add this language. I think you all have copies of it, so that it would say receipt of a clean and complete application. And that language mirrors language that we already have in RSA 420J:4 Roman 2H. And I'm happy to read that to you. It's a very short piece here. So it says this is a requirement that the carriers have to act upon and finalize the credentialing process within 30 calendar days for primary care physicians and 45 days for specialists of receipt of a clean and complete application. In this section, clean and complete means an application signed and appropriately dated by the healthcare provider that includes all applicable information, blah, blah, blah. If there's concern, I mean, I haven't checked with the carriers about this, but if there's concern about the word application, I suppose we could leave it at request. We are just trying to mirror the language that's already in current statute. And it is a defined term. This idea of clean and complete is defined in RSA 420J:4 Roman 2H. So that's what we were looking to, just try to be consistent with that.
Senator Perkins Cook.
Yeah, thank you, Heidi. And I know we talked about this just before the hearing, but I think Senator Susie raises a pretty important point. I mean, the language in the bill says a health carrier shall require all participating providers to notify the health carrier of changes in the status of any items listed in this section. So this sort of implies a simple notification. Again, if it was like just an address change or something like that, I mean, I don't know what's involved in a clean and complete application, but if you guys are open to it, it does sound like we don't want to add a different process in.
Right. So maybe we could just say a clean and complete request. I think that would probably be fine too.
Okay.
So that it doesn't imply it's a complete new application. I understand that implies that there's a fresh,
Yeah.
something new coming in. Yeah.
Follow up if I may.
Sure.
Yeah, and just to clarify that, I mean, do you think, like, just clean and complete requests, does that mean something to everybody?
Well,
or-
I think it does. I mean, what I've heard is that sometimes some of the hangup is that there's not complete information coming to the carrier, and so that
Okay.
in part can lead to the delay. So I
Okay.
think the idea is just, I mean, everybody has an interest in these things moving along smoothly
Yeah.
and quickly.
Yeah.
And so I think it's just
Okay,
that's the idea.
understood.
And I did want to just say, speaking to the concern that Senator Susi raised about this particular patient who've kind of found themselves in a sticky situation, I guess, there are laws on the books that say that if a contract is canceled between a carrier and a provider, and I think if credentialing fell through the crack, that would kind of be the implication, that the New Hampshire law guarantees that the patient has 60 days continued access to the provider under the same terms and conditions as if the provider were still in network. And there's another section of law that allows the insurance commissioner to extend that original 60 days by an additional 60 days, so that the patient could actually have 120 days of coverage. So I just wanted to bring that to your attention, that there is a safety net there. And I'm not sure if folks weren't aware of that, but that is there, available for patients, so.
All right, so if we were to change this to the carrier shall act upon the change in the clean and complete status request within 30 days of receipt of the request, would you be okay with that?
I think that sounds okay to me. I mean, obviously I haven't checked with the carriers about that, but that I think that's reasonable.
Senator Susi, can I have a thumbs up or down on that?
I don't know, does it, it seems unnecessary because of the end of the sentence is, or shall notify the provider of the reason for the delay or inability to act. So if they want to bring up what that would be the issue, right? It's not complete, or doesn't meet our requirements, or whatever.
It may be a
they-
bit
if you-
redundant, but it does make sure that they understand right up front that it has to be clean and complete. I don't know that it harms the language to have it there.
Mr. Chair,
Yeah.
it seems like there's some confusion here. So if we can hold off this bill, and maybe when we come back, and get someone from the insurance department to come in and clarify all of this. To
We
find
can.
out what's the correct language, so that way we're all on the same page.
Is that the will of the committee? Or if you do
Sure.
want to talk about it for a few minutes and you come to
Yeah.
a consensus, we've got
another
a couple of the
option.
bills to work on.
Yeah,
If you've got
sure.
time to do that?
Yeah.
Senator Susi,
Yeah.
would you have a minute to do that? Sure. If you don't, we can hold it for 2 weeks.
Okay.
All right, so why don't the two of you do that, and if you come to something, let us know, and we'll go from there. All right,
Okay.
thank you.
Okay.
All right, let's go to, let's see, 149, we're holding, hold on just a minute, I gotta make some notes here, I'm sorry. And so we're holding 72 at this point. I believe our final bill is 205, right?
We have 205 and 212.
Oh, I'm sorry, I missed 212.
And 203?
So,
All right, what are we doing first?
and what?
205?
203, we're
Yes, we're holding.
holding. Oh, I'm sorry, I didn't tell you that, I wrote it on my notes. I'm not gonna do that one yet, we're not quite ready to do that. I'm not quite ready to do it yet, so my apologies. I had already wrote hold on it, I just didn't tell the rest of you
To
that.
the 8th, right?
Yes, for 203.
March
Sorry about
8th.
that.
Okay.
Just while we're on that, is there anything I can work on to support that bill that might address any concerns that folks have?
203?
Yes.
So one of my concerns is
Yep.
we heard from the, in the governor's address that he has a major overhaul of OPLC that he's looking to do.
Okay.
And I'm not certain whether it's this board in itself may not, it may be one of the boards that he's looking to remove, I don't know.
Okay.
Because I reached out to the commissioner or director, is that a director or commissioner? Director, I'm sorry. The director, Director Courtney, and had a conversation with her over the weekend, and I asked her
Yeah.
to get some information to give back to us, and she hasn't had the opportunity yet.
Okay.
So that was the reason for my hold.
Okay.
I wanted to know how many cases that the board had adjudicated and
Yeah.
how often they met and some
Yeah.
things like that, so that I could better, improve my knowledge on the board itself and how they acted, because it is it has some legal standing when it does give a remedy, and if we're
Yeah.
going to look at changing that board, we could be really having a significant impact. And so I just wanted to make sure that I understood how the board itself truly functioned. And I do have a meeting scheduled with them today, if I have the opportunity to take it, but I'm not certain that I will because of our change in schedule with the Senate. So
Okay.
we will see on that. But that was a reason for me wanting to hold it, is I wanted some more information to understand.
Okay, that's really helpful. Would you guys, one of the amendments I was interested in making is to give tenant associations standing at the board, and so
Okay?
maybe I can work on that amendment if there's no immediate objections. Okay, and then depending on what your investigation finds out, we can.
We can certainly look
Talk
at
about
that.
it
I mean,
more.
my
Okay.
original thought was to kind of re-refer the bill, because I wasn't sure we were gonna have time enough for me to get the info I needed.
Yeah.
But, we do have 2 more weeks, so I'm willing to wait
Yeah.
for that and make sure that we understand what we're looking at.
Okay.
And, but certainly if you have an amendment you wanna work on, please do.
Okay. Okay.
Okay?
Thank you.
All right, everybody good on that?
Yep.
Are we
We
doing
might as well go to
205 or hold?
205.
Oh, we are doing
Yeah,
205.
let's have a discussion on that.
Mr. Chair, I move on to pass on 205.
Second.
We have a motion of ought to pass, and I've gotta get there myself. And would you like to speak to your motion?
Yes, thank you, Mr. Chair. Mr. Chair, this is an issue that the legislature has struggled with for quite a while, about giving our state retirees a cost of living allowance. As it was mentioned during the testimony, the Decennial Commission supported this idea, and I've served on the Decennial Commission, and I do agree that it's time that we really start to look at this issue, and I think this bill is a good first step, and so I am going to support this bill. I mean, right now, we do, at the pleasure of the legislature, give a one-time 13th check for $500, but when you have retired teachers that are struggling, that can't, they're struggling in today's economy like everyone else. I think as retired employees that dedicated their lives to our state, their working lives, that we step up and we do the right thing.
Further discussion?
Yeah.
Oh, go ahead.
Okay, I was just gonna say, I'm really glad to hear the support for this. I think we heard some really compelling stories, and there were many that, I think on that day showed us why this was necessary. But one that particularly stuck with me is that, our Group 2 retirees were not eligible for the 8.5% increase that just went in for Social Security, and so it's just one example of why we know the cost of living has increased, and we should do justice to those that have served our state for so long. So just appreciate the committee's support.
It was a 5-year waiting period, too. 60 months, so.
I'd also like to bring out the point, Mr. Chair, that we had last session a really good discussion about this particular issue, and it was decided at that time that we wait because it was not a budget year. So now we are in a budget year. I think it's time we tackle this issue and begin to have those discussions, and this is the first step. If we can pass this bill, we can get it over to finance, and finance can really take a look at formulas, whatever else is in here that deals with the fiscal amount. We know it's going to cost money, but it's an investment in our employees just as they invested their working lives in our state. And it's time we tackle this. So I'm going to support it.
So while I agree with all of the points you've all made, my concern is that we as a Senate take a position of giving a COLA on an ongoing basis. It's going to have a significant impact to the unfunded liability that we already have. As we heard, I know we didn't have a fiscal note, I'm not sure if we have an updated one yet or not, but we did hear from, I believe it was the retirement system, that this was gonna create almost $120 million impact on the unfunded liability, which is currently at about $5 billion right now. That's my concern, is that we are taking a position as a Senate of giving a COLA, in which to me this is an issue that should be done in collective bargaining. And I'm not opposed to people having money they deserve. I'm certainly not, and I certainly understand the situation that the folks raised. I understand the impact of a limited fixed income and the high amount of inflation that we're currently seeing. I'm concerned about taking that position and the fiscal impact that it will have on the state. I totally agree that this conversation needs to happen in finance, and I think that's the appropriate place for it. So I won't be supporting this for that reason.
You're not supporting the policy of raising the COLA
I'm correct, because I'm
because you
concerned
don't
that
want to give it to finance?
because I'm concerned that
sorry.
it creates a policy
Okay.
of giving it, and I think this should be an issue that this bill should have really gone to finance, is what I think, because it has such a high fiscal impact. That was my opinion. I know we're going to be seeing this again in finance, and I respect that. I know we have the votes to do it, but that's my concern of setting that Senate policy.
Yeah.
Mr. Chair?
Yes.
I would also like to point out to the members, this is also, I believe, we can look at it as part of a package of recruitment and retention. We're struggling to fill our own positions at the state level, and I think we're all aware, even our state troopers were down about 70. Knowing that we're going to be doing this, I think is going to help fill in our ranks, so.
Fair enough?
And, well, we did hear testimony, Maine, Massachusetts, Vermont already have automatic COLAs, and we're competing with them. And we have seen an exodus, particularly of teachers, down along the southern border who can jump and teach somewhere else where their retirement package is going to be guaranteed, and it's not going to be subject to the whims of whatever legislature comes in every 2 years. And I know I would love some security, knowing that, particularly if I'm going to be working in an industry like teaching or snow plowing, or these are the people who keep our communities running, and that's part of the social contract, is that they take care of us on their front end, and we take care of them on their back end. So as a policy, I think this is, it's time. It's time. And challenge finance to figure it out, because that's their job. Ours is the policy part of it.
Further discussion, Senator General.
A question for you, Mr. Chairman, because you had mentioned that it's at the collective bargaining section. So if they're collective bargaining teachers, it's usually every 2 to 3 years they have collective bargaining. Would they actually go out to a bargaining verbiage for COLA once they retired?
Not the current retirees, it would be for the future retirees, that's correct. But this is a negotiated settlement that, that this is what their retirement plan was. There was no guarantee of COLAs when they were in their current retirement plan that they are on. And so we're sort of going back and changing that, and it's certainly the will of the legislature, the purview of the legislature, to do that. And I understand that. I'm certainly not trying to be, nothing against state employees. I'm concerned about the fiscal impact. And I know I'm on finance, so I'm going to have to look at this again.
You just get to delve into it a lot more different.
I do.
Oh, I see what's going on here. I see what you're doing.
I get to do it twice.
I just want to remind everyone too that this is only for retired employees who have been retired for at least 60 months prior to July 1st of 2023. This is not a way throwback.
Right.
It's not a years back, clawback, so it's.
Understand.
Yeah.
And
I
I
mean,
think, and that certainly is an important piece, and
Yeah.
I think that helps. But I know I'm gonna have to look at this again in finance, so I'll take a deeper look there. But that's my initial blush from here.
See what you're doing.
Any further discussion? All right, seeing none, all those in favor?
Aye.
Aye.
All those opposed will be me, nay. And the motion carries, and who would like to take this out?
I could take it out. Unless Senator Carson would like to take it out.
No, you can do it. I'll
Want to
back
rock,
up.
paper, scissors for it, or? No, all right.
Senator
all right.
also.
We're the backup.
They have to be blunt scissors.
All right, our
Yeah.
final
Can't use them
bill.
in the double fish pool.
They have to be blunt tip scissors.
Blunt tip scissors.
All right, now, wait, I have a gavel, don't make me use it. No neck tourniquets, right?
Yeah.
For one. Take
Okay.
Senate Bill 212 is our final bill.
What an amazing bill this is.
We might have a difference of opinion on that one.
I just think like, wow, it's a beauty. Poetry, if you read it out loud.
And you'll probably be mad at me if I move ITL.
Oh, I would, yeah, that's gonna
That's gonna sting.
that's gonna be problematic.
Um,
You don't get to come down to the bougie bunker for chocolates. No, sir.
I'm sorry,
Are you though?
I
I
am.
don't think you are. Okay, where is my committee
So we have a
report?
motion of ITL and a second by Senator Gendro. Do we have, I'm gonna recognize Senator Altschiller to speak to, because I bet she wants to.
Yeah. Well, you know what? I would actually be curious as to your objections before before I roll in. Tell me where you both are stuck. Oops, let me shut this down.
I currently just don't see the need for it. I listened to the testimony, and in full disclosure, my wife is a massage therapist. And I listened to the testimony, and I listened to all the things that were there, and I just didn't come away from the hearing feeling like it was something we needed to do. It was another level of licensure that we didn't need. That I couldn't convince myself that we did. And I talked to my wife about it as well, and had a good conversation, and because she knows the issue. And I understand, I partly understand what you're trying to do, and I just couldn't figure out that this was the right way to get there myself. I think we're putting on a lot of.
Do you see a different path?
I don't know.
Okay.
I just couldn't see that this was the right one. I do understand that there is a concern perhaps.
Mm-hmm.
I just think we're putting an onerous regulation on a lot of people that don't need it. And that was my concern.
Okay.
And so that, I couldn't quite get to saying, yeah, we need to do this. So that's why I moved ITL.
Okay.
Fair enough?
No, but I have a response. I just
That's
want
right.
to hear from Senator Gendro on her objections.
Totally understand where you're
Yeah.
coming from with this. It makes total sense, but I would have to agree with Senator Pearl.
Okay, well, let me reframe it for you this way. Right now, we have licensure requirements that are kind of bookends to this industry, right? On the left hand, on this side, and 1/2 dozen other, like clockwise, counterclockwise. Over here, we have people who give massage as part of another service. And I'll use as an example, pedicures. Had an amazing one this weekend, highly recommend. And when I go into my salon, there is a frame on the wall with a picture of everybody's license. They have to be licensed to perform manicures, pedicures, and deliver these massages. And there is a menu of massages that can be that you can get at this particular salon. So that's one end. They're licensed. They are subject to all of the rules and regulations around their licenses with OPLC. Also have to have certain health standards because they're a licensed business. Over here, we have physical therapy, right? So, which may be going on Friday. And also here. So I get both on either side. Also licensed. So my OT licensed, my PT licensed, and they are subject to the rules and regulations of OPLC, right? In the middle are practitioners who are also doing massage in that bookend space between the low level over here, the medically necessary and prescribed over here, and in the middle, we have people who may or may not have achieved a level of education in the practice that they are purporting to practice. And there's no requirement, and the state doesn't know somebody who is purporting themselves to be, for instance, a practitioner of Asian bodywork, which has 17 different recognized forms and styles. And they actually have a professional organization that provides professional development, best practices, updates on technique, coalition building within practitioners. You know, they have all of these things that everybody over here and everybody over here also enjoys. But if you are an Asian bodywork practitioner, there's no requirement by the state of New Hampshire that you are actually an Asian bodywork practitioner, right? And some of these practices, some of the 17 forms, involve applying extreme heat, cold, stretching, and palpitations, which, you know, if done incorrectly, like chiropractors also have to be licensed, you can really hurt someone. Same thing with massage. There are many different types of massage. Just because I got a massage and I took 2 classes doesn't make me a masseuse. But I can call myself one in New Hampshire, and I can put up a shingle, and people do. They're doing it. It's happening. I got two in my district right now. So these practices of massage and reflexology, structural integration, that is working on connective tissue. Without real training, you can do damage to someone. And part of the concern too is that people who are seeking this middle space, so on this end of the bookend is it's a very targeted space. It's a massage of just your hands or just your feet, right? Nothing in between. And the physical therapy is targeted at an injury, right? And so there's a cooperation with the patient and the doctor to get to the physical therapist who is working on a specific goal. In the middle, what people who are seeking massage are stressed out, perhaps traumatized, want to recover from, a sports injury that they don't want to go to a physical therapist for. There is all sorts of reasons people seek out massage, but what they're seeking out may not be what they get because we have no standards. We have no licensure. So it's a consumer protection space that we want to protect people who are going to get an actual massage, want a deep tissue massage or a stress relieving light massage, are going to get that from somebody who actually knows how to be a masseuse.
All right, Senator, so we have licensure required for massage therapists in New Hampshire currently.
Mhm.
They are also required to get continuing education to maintain that license, and they have to do that it's currently 3 years, but it's going to move to 2 with the revamping of the OPLC. If you have concerns with the level of qualifications for a license and practicing, that's a different conversation than licensing the facility itself. And so that conversation I would be willing to have with you, but licensing the facility, I think, doesn't address the concerns that you just raised.
Well, if you license the facility, the people working in the facility have to be licensed.
They currently do now in order to operate. They absolutely.
You don't have to.
They absolutely have to have a license to operate as a massage therapist in the state of New Hampshire currently. They're not allowed to operate without one. Now, will they operate without one? That's a different thing. If someone's willing to break the law, they'll break the other law too. But they, in order to practice as a massage therapist, you are required to have a license in the state of New Hampshire.
The practice does
That's
not
correct.
have to have a
The
license.
practice does not, because it's a business entity. It almost goes back to the other
This
conversation.
is what we were talking about.
On the other bill.
Mhm.
I agree with you. But licensing the business would still not stop someone from acting badly if they choose not to. They're currently required to have a license to practice as a massage therapist in New Hampshire. That I know for certain.
Their location, though, is not subject
Correct.
to any oversight whatsoever.
The normal
And that's what
oversight-
we're looking
right.
for, and that's what we were talking about earlier, is looking for that space.
Understood. I
Yeah.
understand that you want that. I'm not quite convinced we need it. Fair enough? All right, Senator Constant, I'm sorry, go ahead.
Oh, no, that's okay. EDNA has seen this bill before, and we have, decided that this was not the way to go. For the most part, we don't license the individual and the facility. So I understand what, our colleague wants to do. I just don't think that this is how we get there. And I have, what do you do with a sole proprietor?
They're exempt.
Because I'm looking here,
I know you had an
Yeah.
exemption,
There is an exemption.
and I appreciate that part of it.
Yeah.
Yeah, so that people who do,
Page 4, line
Yeah.
5 through 7.
Yeah, I
Five
see
yeah,
through
because there are
but-
people who, travel with their table to come to your house, or go to your, hotel room when you're on vacation, and they are not subject to this. We are looking at those brick and mortar spaces.
So what about sole proprietors who
I'm-
operate together and share a space?
It's two, or it is, I think we did 2 is exempt.
'cause, Mr. Chair, I'm looking on page 4,
Yeah.
beginning in line 5. It's section 14, new paragraph definition, and it defines a sole proprietor, but I don't see where it exempts them. There's no exemption there. And then it moves on to section 15, new paragraph. There's no exemptions.
But
So
on page 3, line 11, the
Page-
requirement for establishment licensure under paragraph 1 shall not apply to a sole
Okay.
proprietor of his or her business or independent contractors.
usually the definitions come before, so now I kind of have an idea what as you're reading through.
All right, further
Yeah,
discussion.
and Mr. Chair, if you look at section 2 up above on line 7, in addition to licenses issued under paragraph I, the executive director may issue an establishment license to an applicant who does not hold a personal massage therapy license, provided the owner employs a licensed massage therapist as manager. I mean, it's a little convoluted.
Well,
If
I
you
could,
want to license the business, you license the business. So I think there's this intersection of licensing the individual and licensing the business that, in my mind, just doesn't seem to reflect and work well. So I just think this needs some more work, and I can't support it at this time.
Further discussion. Nope, all right, seeing none. All those in favor of ITL, say aye.
Aye.
Opposed?
nope,
Nope.
3-2. We won't put it on consent.
I think Senator Pearl, I think you should take this one
You
to the
think I should
floor.
take this one to the floor?
Yeah.
But that's the beauty of being chair, is I get to pick who does.
Yeah, but then, there's 4 of us and only 1 of you, so we can say, why don't you take this one out?
That is true. You can do that.
Respectfully, sorry, I think that for 72, we might have something.
Yes.
back.
Yeah,
Okay.
so.
I will take it to the floor. Heidi, did you guys come to a resolution on this? Sure, come on.
Good morning again, Mr. Chairman. We would like an extra week or 2. I think you said you're coming back.
2 weeks.
2
Yep.
weeks, so
Okay.
thank you. We'd appreciate that. Thank you.
So we have
Anything further before we go out of exec from the committee? I think done a great job, thank you all. We got through these pretty expeditiously, I think.
I think, I move, we come out of executive session?
All in favor?
Aye.
All right.
Okay.
Well, thank you. That will conclude our work for today, and so I will be scheduling on March 8th. I believe it's March 8th.
Yes, it is.
March 8th, okay.
So it shouldn't, hopefully it shouldn't.
We shouldn't have a terribly long session that day. My hope would be no more than an hour.
Yeah.
But-
Well, why don't we can meet at 10 instead of 9.
Oh, that would be nice.
Would you rather meet at 10?
Yeah, let's meet
Or-
at 10,
All
as
right,
opposed to 9.
What's this?
make a note of
We
that,
should be
Philip.
able to do that.
On on
March
Jared
8th?
can sleep an hour longer.
You do have quite a commute, so
Yes, you have a
I'm
long
fine with that.
commute, Much more of a commute than we have.
All right,
So we can make some extra time to get little sneakers on.
right.
To get what?
Little sneakers.
Kids' sneakers
Oh,
on.
my goodness. Do you have someone come in, or do you go to daycare?
Oh, no, our girls are at two separate schools.
I have an 11 o'clock meeting.
Our girls are at two separate schools and we bring them
Oh.
every morning,
my
so,
goodness.
yeah.
Yeah, that's a lot. You get two little ones
Absolutely.
right
Yeah.
at the same time.
yeah. So I usually bring one and my wife brings the other one. Yeah.
I just didn't know if you had like a nanny or something.
No.